Hello and welcome to today's episode of Taekwondo Life Magazine Live. This is Master Marc Zirogiannis. I'm your host, and I'm the editor-in-chief of Taekwondo Life Magazine. We are a member of the Believe Network. Do you believe? We got a bunch of stuff happening today. I wanted to just remind you of a couple of things before we get into the episode, which is kind of interesting, and that is Panda Plan and Eye for an Eye 2. We have some limited Blu-ray available for both of those. You can message us with DVD giveaway as the code, and you tell me whether you want Panda Plan or Escape an Eye for an Eye 2. Eye for an Eye 2 is really good. It's a sequel to Eye for an Eye, and I actually liked it better than the first one, which is a little unusual, but it's really, really good. I coming out of China. Today's episode is brought to you by BetOnline. BetOnline is the world's most trusted betting platform and your number one source for all your betting in 2025. Whether you're a seasoned fan or a first-time bettor, BetOnline is your ultimate game day companion with the largest selection of odds and everything from NBA and college basketball to the NHL and UFC. BetOnline continues to be your number one sports betting source. For every three-pointer to hat trick, BetOnline has you covered with the odds, stats, and more. For every game, every play, every win, BetOnline. The game starts here. That's betonline.ag. And for Escape Eye for an Eye 2, I forgot to mention, we have a review on our website, so you can check that out. Plus all the other places where we post our reviews, IMDb, Rotten Tomatoes, things of that nature. So I got an alert this morning about a California bill. Some people were outraged. AB 1333. And I did a little research today. I wanted to talk about it. It is not specifically designed for martial artists, but it does apply to us. So I figured I would talk about it. It is a self-defense limitation, or at least that's what it's the people who are against it are talking about. Those that are for it have a little bit of a different view. But I got something from the NRA today saying California bill to restrict self-defense rights introduced in the legislature. So it was sent to us as a press release, obviously because of the notion of self-defense. And I think what we're talking about here is two issues. One is castle doctrine, of course, that relates to your safety in your home. This has sort of come up over the course of the last several years. Florida happens to be a place where the castle doctrine is probably strongest in the country. And then, of course, standing your ground measure. Those two things are somewhat interrelated, and we'll talk about those and we'll explain those. But California, it seems, there is a bill that's pending that was passed by, or was introduced by California Assemblyman Rick Chavez Zbur. I don't know how to say that. That's AB 1333, and that's an update to California's self-defense laws. Now, essentially what we're talking about here is the side that has promoted this law is saying that it's just designed to promote some de-escalation matters, to be able to encourage people to not use deadly force when it's necessary. Now, this applies to guns, but it also does apply to martial arts and martial arts self-defense. Case in New York, most noticeably and most notably is the Daniel Penny case on the New York City subway. He was acquitted, but he ended up having to go through a trial for, not in his home, but in the New York subway, subduing an assailant and taking his life. And it became a murder trial, and it became a big source of controversy. So the idea about AB 1333, according to the proponents, is it does not affect your ability, your castle doctrine, your ability to protect yourself in your home. It's designed to provide, it's an anti-vigilante, is what they're saying. It's an anti-vigilante law designed to disencourage or disincentivize people and actually punish people for using vigilante measures or non-escalation measures outside the home. Now, one could argue that, increased police presence, punishment of misdemeanor crimes, property crimes, things like that would perhaps abrogate the need for this, but I don't really want to get into that's a whole nother pathway to get down. This law is modeled on one that exists in about 12 different states, and it really is sort of the way it's being discussed is it's designed to be a alternative to fatal action, so that you have to try to use other means outside of your home before using fatal action, which to me sounds pretty reasonable. Even as a martial artist, we learn this. But the people who are against it say it's false, that it is a lot of law enforcement and things of that nature are saying it is designed to limit your rights and punish the victims. And now for a word from our sponsor. So we are back. So the NRA is saying that this is an example of criminals first bill that guts self-defense in the state of California. It eliminates the Californians' no duty to retreat protections for individuals that are forced to defend themselves. It makes it easier to prosecute the victims and forces the victims to comply with violent and criminal demands, becoming further victimized. Now, I do understand that that's a perspective. I'm not sure, again, that's coming out of the NRA, that's in fact the entire perspective. There was a fact sheet that was been circulated by the proponents of the bill. I'll tell you a little bit about what it says. And again, this is all subject to fact check. But the bill is designed to de-escalate situations. It's designed to respond to dangerous trends by clarifying California state self-defense laws and require peaceful disengagement outside of the home when possible. Saying that it's modeled on that of 12 different states, and it does not in any way restrict Californians' right to defend themselves. It does not impact the Castle Doctrine, according to this, which is codified in state penal code, and we can check that, and allow someone to use deadly force in their home with the presumption that they are facing imminent bodily harm. Californians involved in violent situations will still be able to defend themselves, will still be able to protect their neighbors. It's saying that this is a false accusation, but saying that they want the use of common sense. Saying that if you're in a violent situation, you can protect yourself, but that you shouldn't use excessive force or homicide and then try to justify it as self-defense. You are still entitled to use deadly force. However, you seem to be able to show that you used some level of de-escalation or disengagement, if at all possible. Okay? Under the new language, the Californians may still use deadly force when necessary in situations where imminent danger of serious bodily harm. If you're under attack, you may use it. It simply clarifies how the law operates. And that is really the gray area here and the area where it seems the controversy. I certainly do understand some of the concern here, and certainly law enforcement has come out against it in a lot of ways. And but the sponsor of the bill has been pretty good about trying to explain what it means, saying that when a person is outside of their home is what we're talking about, and when they utilized more force than when necessary to defend themselves, and when they knowingly could have gotten away or prevented a situation, that's what this would really obligate ordinary citizens to. Something that probably most people probably do anyway. Assemblyman Rick Chavez Zbur's AB 1333 was never intended to limit crime victims' rights or to defend your family or your home. This goal is to prevent wannabe vigilantes like Kyle Rittenhouse, We certainly know that from the George Floyd protests, from provoking violence and claiming self-defense after the fact. We will amend the bill to make this crystal clear. So it seems like they do understand that there is some gray area. So here is my concern about the bill. I don't have a problem with the bill per se, because I think most reasonable people do adhere to and understand their obligation. Most people are not out looking for vigilante justice. Most people are not looking to commit acts of harm excessively. And again, we're talking about outside the home. I am a believer that if someone comes into your home, to the extent possible, you need to do what you need to do to save your family. My problem is that these are so fact sensitive that I do understand that there is a putting the burden now upon the victim to prove that they de-escalated, or putting a burden on the victim to prove that they didn't use more force than was necessary. The Daniel Penny case is an example. He's somewhat of a hero. In my mind, he was a hero. A gentleman on the train who was on drugs, who was threatening people, who was talking about killing people, old ladies. He was talking quite violently. It was quite frightening, and Penny subdued him. Now, there is a little bit of an issue there, because Penny had some martial arts training and some military training, and so as a result, they put a higher level of burden on him, and he ended up having to go through this trial, which could have really, really hurt him. I think most New Yorkers who've ridden the subways understand. Most New Yorkers understood that this guy was just an ordinary guy who wasn't out there looking to create any harm, and that, sometimes these people on the subway, and that's another issue, should be dealt with. And that was sort of my point earlier, is that if we're not, as a society, as a police force, as a government, going to make the streets safe for ordinary people, working people, people that are walking around, to be able to do what they need to do, then you put them in a precarious position that they now not only are, it's double jeopardy, where they're not only unsafe, but now they stand the risk to be prosecuted if they defend themselves, defend their loved ones, or defend their neighbors and friends. So definitely something to think about. I don't know the trajectory of AB 1333. I know that you have to be careful about what you read and what you don't read, because, I certainly know the NRA's position seems to me to be a little bit too extreme on the other end. However, I'd love to hear your opinion. As martial artists, one of the reasons why we train is to protect ourselves, but certainly we want to be able to use justifiable force and not excessive force. That's what we teach our kids. That's what we teach our people. But those things sometimes are subjective. What would a reasonable person think? Is there a weapon involved? Where are we? How many people were involved in being assailants? So all things to look at. I'll keep you informed as to the status of the bill. But certainly I'd love to hear your opinion on this topic. I think to some degree, because it's in California, there's a notion that just, there's victims' crime rights. And that may be true. I'm not a California resident. I know my perspective from New York. When you tend to be in what you call a blue state, there tend to be a little bit more of a emphasis on these issues. However, I think it is important that there be a balance, right? We shouldn't have the right to commit vigilante justice. But we should always have the right to defend ourselves. And, in the words of Abraham Lincoln, which I'll end this with, right? We always come to this conversation and this crossroads. And Lincoln is quoted as saying, I don't know if he actually really said it, I'd rather be tried by 12 than carried by 6. And I always do think about that, I certainly don't want to end up in a situation where I'm going to be tried, but I'd rather be tried than be killed. So this is Master Marc Zirogiannis. This episode has been brought to you by Bet Online. I look forward to seeing you on the mat.
Do you believe?